A permanent claim on the sovereign equity of the United States should not be a closing gift for a temporary transaction.
So I want to understand how you are responding to the government's argument that because temporary visitors and undocumented immigrants are still governed by their home countries, and in the government's take on this, you can't have you can have allegiance to two different sovereigns. Those groups can't have the requisite allegiance to be subject to the United States for the purpose of the 14th Amendment. That's what I hear the government saying, but I do think that that seems to rest on a different understanding of allegiance than what was in the English common law, and that when we understand what the English common law thought about allegiance, you can see that you can have allegiance to two different sovereigns at the same time. This kind of goes back to Justice Alito's questions. I mean,
we are currently auditing a material discrepancy in the 14th Amendment's internal controls, where a physical presence for a few hours is being used to trigger a lifetime of vested rights that the American taxpayer must eventually amortize. This is the ultimate identity arbitrage, a scenario where the sovereign ledger of our nation is being watered down by a legal interpretation that treats allegiance like a temporary lease rather than a permanent equity stake. While the media focuses on the wild rants of the bench, we are performing a sovereign asset audit to see if the infrastructure of citizenship has suffered a systemic collapse that allows for the unauthorized extraction of our national resources. I am Camilo Motado, and this is Camilo's House. As a certified public accountant focused on forensic data verification, I approach the Constitution like a master operating agreement that has been interpreted into insolvency. In a standard audit, we look for material misstatements that allow external actors to claim internal assets without a proper exchange of value. Today, we are auditing the Supreme Court's latest birthright citizenship hearing in a case that seeks to reconcile the naturalization ledger with the modern reality of global travel and undocumented migration. We are documenting the forensic conflict between Justice Samuel Alito's Conflict of Interest audit and Justice Ketanji Brown Jackson's English common law fork. This is the final reconciliation of what it means to be subject to the jurisdiction of the United States, and the audit opinion we reach will determine if American citizenship remains a premium asset or becomes a liquidated commodity. The operational trigger for this hearing is the specific phrasing of the 14th Amendment, which grants citizenship to all persons born in the United States and subject to the jurisdiction thereof. From an investigative standpoint, the jurisdiction clause is the primary internal control. For over a century, the operating standard has been just solely the right of the soil. But as a CPA, I track risk exposure, and Justice Alito has identified a massive systemic risk in this interpretation. He performed a stress test using the example of a child born here to an Iranian national who entered the country illegally. Under current standards, that child is an American citizen. However, as Alito points out, that child is also an Iranian national at birth and owes a duty of military service to a foreign sovereign, a sovereign that is currently a geopolitical competitor and a sector risk to the U.S. This creates a double booking of allegiance. How can an asset be fully vested in the United States while simultaneously carrying a military liability to a foreign power? In auditing terms, this is a conflict of interest that renders the allegiance ledger. If a soldier of a foreign sovereign is also a voter in the domestic sovereign, the internal controls of our democracy have reached a state of functional impairment. This is where the Jackson analysis enters the forensic trail. Justice Ketanji Brown Jackson attempted to perform a reconciliation of the term allegiance using English common law, the legacy software that our legal system is built upon. She argued that allegiance is not just a heartfelt emotion or a political choice, it is a jurisdictional footprint. She used a personal transaction example. If she visits Japan and steals a wallet, the Japanese authorities can arrest her because she owes local allegiance to their laws while on their soil. In her view, allegiance is simply the authority to control. If the government can arrest you, then you are subject to the jurisdiction. Jackson is forking the definition of a vested interest. As a CPA, I find this to be a material accounting error. There is a fundamental difference between a temporary lease and total ownership. To say that an undocumented immigrant or a birth tourist has allegiance because they can be prosecuted is to devalue the concept of sovereign loyalty to the point of total liquidation. Being subject to the law is a passive status. Being subject to the jurisdiction in a constitutional sense implies an active partnership in the sovereign enterprise. The forensic discrepancy in Jackson's reasoning is that she is using common law exceptions to justify a systemic loophole. The English common law was designed for a monarchy where every person on the soil was a subject of the crown. But the United States is a republic built on consent of the governed. You cannot forcibly naturalize someone into a republic simply because their mother transacted a delivery on the soil. This management override of intent is what has generated the wild rants headlines. By amortizing the requirements of citizenship down to physical presence plus arrestability, Jackson is creating a low-bar entry that impairs the value of the American brand. It allows external actors to extract a lifetime of social benefits in exchange for a short-term visit. We must also audit the Wong Kim Ark precedent, Wraith legacy case from 1898 that serves as the primary guidance for this sector. That case confirmed citizenship for a child born here to Chinese parents who were lawful permanent residents. But as a forensic investigator, I look at the contextual variance. The parents in that case were lawfully admitted and had a permanent domicile in the US. Today's market reality involves birth tourism and illegal entry, where there is zero intent to vest in the American experiment. Treating these two transaction types as the same is a failure of internal controls. It is like treating a day trader the same as a long-term shareholder. They both use the exchange, but their impact on the system is fundamentally different. The social cost of this birthright arbitrage is an unrecorded liability that is currently bankrupting our local governments. When non-vested actors can generate new citizens through a border crossing, the public ledger faces an immediate cash outflow for education, healthcare, and infrastructure. These are unfunded mandates that the existing shareholders must balance with their own equity. The management in Washington refuses to audit the impact, preferring instead to massage the narrative of inclusion. But from a forensic accounting perspective, you cannot have unlimited inclusion with limited resources. That is a formula for systemic collapse. My forensic verdict on the Jackson allegiance analysis is that it is a strategic redefinition designed to protect a failed operating procedure. Collapsing the distinction between natural and local allegiance, she is providing a legal shelter for birthright arbitrage. Justice Alito's conflict of interest audit is the more reliable report. You cannot have a unified sovereign ledger if your citizens carry military liabilities to enemy nations. I disagree with the current interpretation that allows for citizenship by geography. It is a legacy bug in the constitutional software that was never intended to be a market loophole for the entire world. The 14th Amendment was a financial and social restructuring designed for people who were already vested through their labor and presence but were denied equity. It was not a coupon for temporary travelers to mint new citizens. To restore the value of the American ledger, we must liquidate the birthright loophole and recapitalize our citizenship through naturalization and vested lineage. I want to hear from you. Does Justice Jackson's local allegiance argument hold any audit value for you, or is it just a semantic redaction of what it means to be a patriot? Let me know in the comments. Your perspective is the only audit that matters when the sovereign equity of our nation is sitting on the negotiation table. I am Camilo Motado, and this is Camilo's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.